In the ongoing question of how many genders are there, one schoolyard boy has an opinion in wearing a shirt that says there are only two genders and then being disciplined. Then wearing a shirt that says there are censored genders, still being disciplined. I am imagining the school allows people to wear shirts that express LGBTQ question mark, ampersand, squiggly mark, upside down question mark, caret symbol pride as much as they want, but apparently not with the "are only two genders" shirts. So I'm assuming this is what we call viewpoint discrimination. That is potentially per se unconstitutional. The flag burning case suggests as much. With Texas v. Johnson, with the flag burning case, might be able to restrict the topic, that's subject matter. But if you allow the subject, but only some perspectives on the subject, viewpoint discrimination. So we're in a whole new world of unconstitutional. But the school's doing it anyway. Let's learn more about this story. In Massachusetts, the Middleborough 7th grader is asking a Boston court to halt his school ban on t-shirts that say there are only two genders, to which he was forced to go home, sent home for the day because he wouldn't take off his shirt, and then wore a shirt saying there were only censored genders, which the school then also ordered him to remove that shirt, violating his First Amendment rights, a lawyer has said. Yeah, I think so. I'm going to go out on the presumption that they allow the LGBT question mark, ampersand, backwards squiggly mark shirts. So not allowing this is a pretty big First Amendment issue, I think. Liam over here wore a t-shirt saying there are only two genders to Nicholas Middle School in March, and the principal of the school, along with the counselor, pulled him out of class and ordered him to remove the shirt, according to the boy's attorney. After he politely declined, school officials said he must remove the shirt or he cannot return to class. As a result, he left school and missed the rest of the day, said his lawyer, who will argue the case. After that, he wore another school shirt that said there are censored genders to protest school officials that only some messages about genders are allowed. As soon as he arrived in school, his teacher instructed him to go to the principal's office, where he's told he couldn't wear that shirt either. So I'm not even allowed to note that. I guess we'll have to go back to wearing the black armbands. Maybe he can wear the black armband and protest and just pull a full tinker, go 180 degrees. The legal counsel that's assisting him is working for the Alliance Defending Freedom, which, along with Massachusetts Freedom Family Institute, filed a lawsuit on behalf of Liam. This isn't about a t-shirt. It's about a public school telling a 7th grader he isn't allowed to hold a view that differs from the school view. Yeah. Viewpoint-based discrimination. Viewpoint-based discrimination. That's a real problem. Public school officials can't force him to remove a shirt that states his position when the school allows every other student wearing clothing that speaks on the same issue. If they didn't allow anyone to wear shirts on the issue, then we'd only be in subject matter discrimination. But they allow some people to express some views and not others on the same subject, viewpoint discrimination. Their choice to double down and silence him when he tried to protest is gross violation that we're urging the court to rectify. The news reached out to the schools for comment. An assistant superintendent declined to comment, saying the school district is represented by legal counsel and this is a matter of ongoing litigation. Yeah, if the courts don't have their head completely up their ass, the student is going to win. So we'll see how it goes. There was a hearing for a motion for a preliminary injunction, which actually was granted, that requested the court to prevent the student from wearing the school while the case proceeds. So the court actually granted the injunction. I imagine we're off to appeal already, because injunctions can be appealed immediately for that interlocutory appeal, because they granted the injunction in favor of the school. So how? Given Tinker, given BL versus Mahoney, how? Were there actual disruptions in the school? What are you doing? The Alliance Defending Freedom is a nonprofit legal organization committed to protecting religious freedom, free speech, parental rights, and the sanctity of life. In the case, Alliance Defending Freedom attorneys argue school officials have adopted a particular view on the subject, that a person who identifies determines whether they're male or female, not a person's sex. They've expressed this view through their own speech, institute school-wide events celebrating the view, and encourage students to engage in their own speech on the subject as long as it's the school's favored viewpoint. School officials admit their policies permit students to express viewpoints supporting the official's view of gender, but forbids it from expressing. Dude, man, that should be easy. I mean, that should be really easy. That's about as unconstitutional as it gets. It's pretty hard, right? You are allowing the subject to be discussed. So you're not even saying no discussion on the subject at all, in which case subject matter discrimination. You're specifically saying, yes, we'll allow discussion on the subject, but only certain views. This should be really easy. And the district court granted a preliminary injunction in favor of the school. Does the district court understand the case law? I'm not sure the district court understands the case law. It is a district court in Massachusetts, but still. Liam wore the shirt to peacefully share his belief, informed by scientific understanding of biology. Now, you can't have that anymore, not in schools. Biology and science? No. You trust the science except when it's inconvenient. That there are only two sexes, male and female, and the person's gender is inexorably tied to sex. At this point, I'm not even sure the term gender is helpful. I'm not even sure the term gender should be used at all. It seems to be just a description of personality traits. So I think calling it personality traits might be better. I'm not sure the term gender really is a useful term at all, but that's maybe just me. The boys' attorney says the case involves the school's censorship of message, along with their decision to silence speech protesting censorship, which violates the Constitution. It sure does, but it hasn't been going well for the student thus far. Thus, that brings us to the story about a schoolboy, 7th grader, fighting the fight for the right to say that there are only two genders and that, biology is the determiner, which, is his view. And he should be allowed to express that view. The school apparently has no problem with the contra view, but has problems with his view. And there doesn't seem to be any indication of actual disruption in the school. It's all prophylactic, which doesn't conform to Tinker or BL, and also doesn't conform with Texas v. Johnson when it comes to viewpoint-based discrimination, among a litany of other cases speaking about this issue. So I don't know why the district court granted in favor of the school. Perhaps they are unaware of such cases. That's okay. Tinker's only been in the law of the land since the 1960s. Maybe the district court hasn't gone that far in their law books yet. Oh, well. But this case will proceed, presumably with an immediate appeal to the First Circuit on the injunction. And that, for the moment, brings us to the end of discussion of this story.